She replies back, no, I already told her I was done. She was asking for ledgers. That's why I had to finish, but I told her I had gone through the bags. She wanted to help with that. I said no. So we know December 12th, the defendant is aware the money's not in the bags. He's in possession of that money, as you heard from Bethany.
All right, I think when we left off, Mr. Perry had started his motion for Rule 29.
Thank you, Judge. In fact, I had just handed the court and Mr. Hardman copies of the case that I had pulled from the 12th District. It's the state of...
I was going to comment on this. You're handing me a case from 1993. Let's see, it was written by Judge Jones with Judge Young concurring, argued by Judge Hendrickson.
Yes, sir.
And Judge Carter, correct?
It's good law, Judge.
Yeah. Okay, go ahead. I'm sorry. I just wanted to comment on all the people involved in this case.
I saw that. Judge, it was a bench trial. I don't know if you've read it, but it was a bench trial. The defendant was found guilty. The issue on appeal wasn't a factual issue. It was whether or not the court made the right call when the court decided to amend to a lesser included offense. So, that being said, in this case, in the case, the court, in reversing the 12th, that is, in reversing the trial court, this panel effectively set the legal standard for unauthorized use of property cases, holding that the offense requires proof that the defendant used or otherwise operated the property at issue in some authorized manner. So that certainly was the significant finding. It also, the 12th went on to say that mere possession or control is also insufficient, assuming that there was no the evidence of the unauthorized use. But again, mere possession or control is insufficient to satisfy the same requirement. So here in this case, the state has not established that Jim had even mere possession of the money in issue. So again, the money in issue, it was in the binder on December the 18th. It was in the binder on December 19th. It was in the binder on December 20th. And Judge, I don't know if it was convenience or I don't know if it was convenience or just an opportunity, but as of the 20th, the money was missing. But it was after the first call. It was after Jim had been to lunch, and miraculously the money's missing. Nevertheless, the evidence still, there's no evidence that, number one, Jim ever touched or possessed or even moved the money. So again, the first prong has been satisfied, but even if the courts should otherwise conclude that Jim had something to do with the money, the evidence has not been established to show you that any touching, any possession was done in some unauthorized way. The facts just don't comport with the ruling in this case, and for that reason, Judge, you know, I think the argument on the theft, that's really an argument for the unauthorized use charges, all 26 of them. The argument on the theft case is that even Ms. Montgomery, who testified today, testified that her December 18 reconciliations on the theft defense, on the October reconciliation, the November reconciliation, and the December reconciliation, not a dime was missing. So again, the state hasn't even established the elements required for the theft defense. And I'll say something else. There was some testimony earlier today, and I'm still on the theft defense, there was some testimony whether or not Jim had access to perhaps even being able to handle the money. Jim was the director. He was over Bethany Monashed. I have to assume that he absolutely had every right to handle money when and if needed. But the fact that the money, and I'm talking again about theft, relating to the element that beyond the implied consent of a person to use money. The state hasn't even established the elements on the theft offense itself, as simple and as basic as they are. So, again, no money was missing, there's no evidence of anything being stolen, but as it relates to each and every element of the theft offense, evidence hasn't even been established to even show the court that someone, again, if it was Jim, somehow touched the money and didn't have the authority to. So if he did touch it, he had the authority to, and without any further evidence, there is no evidence that the intention was to permanently deprive. So again, on the Rule 29, I think that the case that we are citing from the 12th is significant, and the facts that were offered earlier do not constitute the offense of theft. For those reasons, Judge, we're asking for acquittal on both charges.
Mr. Hardman?
Thank you, Your Honor. We're dealing with 26 individuals who have entrusted their money, their funds, their activities to RGHI, and Bethany Motteshed particularly, with the entrustment of those funds in order to be used for the sole purpose of their needs throughout the day as they are part of that 513-day program. And what we know is that in December, and throughout 2024 for that matter, the defendant was taking that money without authorization, without approval, and using it for whatever purpose. We don't know specifically what his purpose was, although you did hear testimony from Bethany Motteshed where she indicated toward the tail end of 2024 the defendant was having some cash flow issues because he had to get another apartment in the city of Lebanon and pay down payments and the like to pay for that. You actually heard him acknowledge that in the tape recorded statement that Bethany took. So we know that there was illicit usage that the defendant was engaging in with regard to these funds. So let's talk about time frame and what the evidence shows to get past the Rule 29, much less, I think we would argue, and I think ultimately I might as well just argue that it's beyond a reasonable doubt. This is a bench trial. The timeline that's involved here. We start with State's Exhibit number 9, and that is the text messages between the defendant and Bethany. It's dated December 12th. Bethany needs to do a reconciliation. She hasn't done one in several months because she's been putting it off. As you heard from her testimony, as well as Jennifer Montgomery's, the defendant is putting off the reconciliations because he doesn't have the money to put into the funds. So Bethany says, because she's being bugged by Jenny, we need to reconcile tomorrow. It's December 12th. The defendant says, we definitely can't do that. So Bethany, supporting the defendant, we know she was supporting the defendant, she was in the wrong, she knew she was in the wrong, says she's just going to be invisible. Defendant says, just say you're not done. She replies back, no, I already told her I was done. She was asking for ledgers. That's why I had to finish, but I told her I had gone through the bags. She wanted to help with that. I said no. So we know December 12th, the defendant is aware the money's not in the bags. He's in possession of that money, as you heard from Bethany, at that point in time. And then Bethany, or at some point in time, Bethany prepares for him State's Exhibit 10, showing the money that's supposed to be in the bags, the money that's missing in the bags, what you have to come up with in order for the bags to have the right amount of money. And the defendant does that. He comes up with that money sometime between December 12th and December 18th. But what he doesn't know is before that point in time, Bethany finally has a bout of conscience. She finally says, these dollar figures that started off as small amounts of money have been getting larger and larger and larger because of his problems, his financial problems, because of this new apartment he needs to get, that I just can't do this anymore. The pressure's too much on me. This shouldn't be done. I need to say something about it. And so between the 12th and the 18th, she goes to her board. She tells the board what has been happening. They meet with her. They talk to her. They then turn that over to the Clear Creek Township Police Department, and they get involved. Bethany comes and sits down with Detective Barton and tells what happened, what was going on leading up to December 2024. Tells him about that ledger that she did, the handwritten ledger for the defendant. Tells him how this process worked, what was going on. Implicates herself, just as she did on this witness stand. No promises are made to her. She has nothing being promised to her when she comes before the police department, where she admits a crime. She admits her involvement in a crime. The detectives, rightfully so, say, okay, we've got this information. I need more. I need a little bit more than just you telling me this. So let's find out. You say he's going to take the money again. Let's find out if he does. Go back, and when he does, let us know if it ends up going missing again. So that's December 18th. We know on December 19th of 2024, at 9:53 a.m., that's the video, State's Exhibit number 2, 9:53 a.m., December 19th, 2024, Bethany takes a video showing the money in each one of these individuals' pencil bags. Money's there. It's accounted for. It's the same money that was accounted for the day before when the reconciliation was done, and that makes up State's Exhibit 6. We also know that in the drawer of the defendant's office is that handwritten ledger, State's Exhibit 10. We see that in the video. We also see an unknown amount of money that nobody has any explanation for where that money is or what that money belongs to in the drawer of the defendant. That is all at 9:53 in the morning on December 19, 2024. That afternoon, 2:21 p.m., December 19, 2024, Bethany has a conversation with the defendant. A conversation she's recording. She's doing it on purpose. She wants the defendant to make some kind of acknowledgement about his usage and his taking of the money. In this particular instance, are you going to take it again? I want to play that part of the clip again for the court because I think it's very important. It shows the defendant's intent.
I'm going to stop you. We're arguing Rule 29. We're not doing closing arguments right now, so I'm going to stop you. I'm going to deny the defendant's motion for Rule 29. The court is required to take all of the evidence that it has received in light most favorable to the state at this point in time, including any inferences that can be drawn from the evidence that was presented. So I'm going to deny the Rule 29. So if we're going to go into closings, then that's something different, and then so let's stop there. I'm going to deny 29. I have to give the state all the evidence in light most favorable to them, together with any inferences that can be drawn from that evidence and most strongly in their favor. So that's why I'm going to deny the 29. With that in mind, Mr. Perry, does the defense wish to offer any evidence?
Regrets, Judge.
All right, so now, we're ready for closing arguments, Mr. Hart. Right back where we started.
Your Honor, if I can, I will go ahead and incorporate all the comments I
Absolutely.
already made, if that's
Please.
all right. So I will start where I was talking.
I appreciate that very much.
And actually, we meant to have that conversation with you beforehand, so I apologize. Again, what I'd like to do is I'd like to play that portion of the conversation between the defendant and Bethany as it relates to the money that was in those bags, the money that doesn't belong to him, that he doesn't have authority to use for himself.
Every day, that's $200 for movies. It's also taco bar day. I mean, I don't know what to do.
I mean, the $200 isn't a problem. We can do that.
200 isn't a problem. So we go to
I
the.
didn't take any money out there yet.
You haven't taken any out yet? Are you going to, or?
Oh yeah, I'm definitely going to.
Okay. Well,
But
yeah, it'll be two. I mean, I have to have at least 20, which is that's $200. So
isn't it $5 a person?
it's 10 a person.
It's 10 a person?
It's 10. It's popcorn pop and the movie for 10. I mean, I just kind of forgot about that. And also,
Oh, yeah, I'm definitely gonna do that. The afternoon of December 19th, 2024. We then get to the next morning, December 20th, 2024. If you remember from Bethany, she says, first in the morning, the money's still there. So they didn't take it the night of the 19th. We know that. December 20th, that morning, it's still there. Defendant leaves for lunch at 11:50 in the morning. Bethany goes back in, checks the binders, takes the video recording, sees that those bags, not all of them, 2 of the binders of the 3, are basically empty of money. The 26 individuals that make up the count of the indictment. That is shown in State's Exhibit number 8, that accounting that the officers did, showing how much money was actually in there, how much is short when you use State's Exhibit 6 to compare against. And each of those individual 26 residents who are missing that money, accounting to $1,383.10. Gone. She reports that to the police department, as she was asked to do. They obtain the search warrant. They come in the afternoon of the 20th, confirm those items are missing. They find the ledger still in the defendant's desk drawer, no cash in that desk drawer anymore. And they find $1,385 in the defendant's credenza in a cardboard box, because the defendant has removed it to use, as he has so many times before throughout this period of time. At this point, he has been caught. And there's evidence separate and apart from Bethany, who in and of herself, I would submit the evidence has proven to be credible with regard to the issues that were going on. She's not a clean actor. Her hands aren't clean. I know that. This court knows that. Everybody in this room knows that. Bethany knows that. But none of this gets discovered but for Bethany Matashed coming forward and saying enough is enough. Shouldn't have done it. He definitely shouldn't have done it. And it's time to say something. And she did, and she has. She's been consistent with regard to that from day one. This defendant took money belonging to these 26 individuals. He purposely deprived them of that money. And then he also used their money without consent, without their authority. I would suggest to you that, there's maybe this argument that, there's no harm, no foul. That $1,385 in the credenza, assuming it's the same money that was taken from the pencil cases, is still there. It's able to be put back into these individual people's accounts. I think that conversation between the defendant and Bethany is a perfect example as to why this is not a no harm, no foul case. For months, Bethany Matashed and the other programmers at 513 had to make decisions on what they were going to do with these disabled adults during the day, what money they had to use on behalf of these individuals based on the amount of money that was in there, based on what they could use for their activities and their participation. And they changed their planning in order to deal with it, as you could hear from Bethany in that recorded conversation. I don't know what I'm going to do. We're supposed to go to the movies. I need this much money to do it. Well, he says, don't worry, it's only $200. I can take care of it. But what other activities did they not get to participate in? Or a last-minute decision to run to Dollar Tree to buy something because that person didn't have money in their account because the defendant was using their money in a way that he had no authorization to do. That, Your Honor, is theft. That is unauthorized use of property of each one of these 26 individuals that by stipulation, they're disabled adults, making his behavior felony behavior. We'd ask for a finding of guilty. Thank you.
Thank you, Mr. Hardman. Mr. Perry?
Judge, thank you. I don't know where to begin. There's no doubt that the money is in the credenza. If the money's in the credenza, then there hasn't been any showing, and there certainly isn't any proof that the intention was to permanently deprive. So the argument from the state really is kind of an emotional and a passionate argument to try to maybe cover the facts. But the facts remain. On the 20th, at 8:30 in the morning, the money was in the bag. Jim goes to lunch. The next thing Detective Barton knows is he's getting a recording from Bethany Monachet. Quite frankly, again, Bethany Monachet is damaged goods. She is a suspect. She is involved. She admits it. She even admits that she's cooperating and she's looking for some benefit from her cooperation. To think that she is now some special person who's come forward to do something superhuman is a mistake. There is no way the state can tell you that it couldn't have been Bethany Monachet who said, my gosh, as of the 18th, money's in the bags. As of the 19th, the money's still in the bags. As of the 20th, the money is still in the bags. I'm running out of time. It's Friday. I'm going on vacation. I want my case consideration. I'm not going to get rid of it, but I certainly could put it in the credenza. And I can save face. Everybody's happy, and we all get on with life. But I've done for the police what I've told them I can do. It's not gone. There's no permanent deprivation. And there's no proof, and I'm talking about between the 18th, 19th, and 20th, the dates that are the critical dates for the unauthorized use of property, not some history that the state's talking about, but for those 3 days, there simply is no evidence that Jim moved that money, and there certainly is no evidence that if he moved the money, that there's some reason to believe that he moved it for purposes of taking it, stealing it, using it. No evidence was offered on those very issues. Judge, I want to go back to Detective Barton. His plan was to set something up that was meaningful. His plan was to definitively catch him in the act. And he instructed Bethany to wait until the money was removed, confront him about why it was taken. And the thought was, Jim would say, oh yeah, the money, I took it. So what does Bethany do? She asked him before the money's gone, was that an admission that he took the money? No. What you just heard there was Jim saying something to the effect, yeah, I intend to take it. He could very well have been talking about money that was different money used, what we were talking about earlier today.